Okay, here we go. So please let everybody know that they are being recorded. Okay, let's go. Right, so today is the last lecture, the last scheduled lecture of the course. Well done for getting this far. I think it's great. Hopefully you've enjoyed it, or at least enjoyed it as much as I've enjoyed presenting it. Your exam is in a little over 2 weeks' time. On the 15th, 6-hour open book. That means you can take in anything. So I would expect to see on your desks extracts or copies of Dean and Dyer and the case law and a few of the things that I've sent you, copy of the acts, etc., etc. So, you know, I wouldn't be surprised if you sort of arrive at the exam with a small suitcase full of all of these things. But having said that, you can't rely on the day on being able to look it up. You know, you're going to have to be comparative in your analysis and understand where you need to look, etc., etc., in terms of the questions. Danilo and Sally and I were talking earlier. For those of you who want a revision lecture, that's absolutely fine. I'll set some time aside for that. I think we should set aside 2 hours. We can go through some of the syllabus. I can answer any questions you have. We can go through some exam technique as well if you think that would be helpful. What I suggest you do is you guys all get together on your WhatsApp group and give me 2 times, 2 2-hour sessions, which are convenient for you guys. And then if you give me 2, I'll choose the most convenient for me. I'm quite busy at the moment. I don't know what's happened actually, but certainly in terms of my practice, it's just gone crazy. So, you know, that's great. The only thing worse than being busy is not being busy when you're in private practice. So it's great. Long may it last. But it does mean that, you know, I might not be able to give you your first choice of time. That said, it doesn't have to be a Saturday morning. It can be an evening or even an afternoon. That's fine. So just let me know a 2-hour session when will suit you. And I think, you know, that's fine. Most of my students every year actually do go for the option of a revisionary lecture. And I think they've all found it helpful. So let's do that. So I'm going to leave that in your court, and you just get back to me. You can have a designated spokesperson who's going to chat to me about that. And yeah, I'll take it from there. Okay, all right. Let me just get ready here. Okay, today we're going to talk about designs. Designs cover how something looks or the functional purpose. Designs are judged by the aesthetics, and that would be judged solely by the eye or judged solely by the function it performs. So the South African Designs Register is divided into 2 parts, aesthetic designs and functional designs. And aesthetic designs are, they're the traditional designs. The aesthetic designs, you know, have counterparts of corresponding species of protection in most countries around the world, the UK, Australia. In the US, they're called design patents, and they are there to protect features judged solely by the eye. The South African Designs Register is unique in that we have what's called Part F, which covers functional designs. And it's really important that you understand the difference between the two and be able to compare the protection offered by the two, and are able to talk about which one is most appropriate, etc., under the different circumstances. So that's what I'm really looking for today, is a fundamental understanding of the difference between aesthetic and functional designs. Okay, so registered designs can be aesthetic or functional and provide for the protection of the appearance of an article resulting from a particular design being applied to that article. So we need to, we'll talk about it being applied to an article. There's usually some, there's some jurisprudence behind this concept of being applied to an article. So a registered design is, you know, obviously part of the suite of intellectual property, patents, trademarks, and copyrights, and it's the mechanism by which the outward appearance of an article is protected. And so, you know, there's a lot of case law on aesthetic designs. There's nothing on functional designs because functional designs are unique to South Africa. So, you know, and we haven't had any court cases on it because the designs come from the Designs Act of 1993, So, I mean, it's been around for 30 years, but there actually hasn't been too much case law on this unique species of design, the functional design. Okay, so one of the really seminal cases when it comes to design, certainly aesthetic designs, is AMP versus Utilix, and I think the judge in that case really summed it up here. He said, those who wish to purchase an article for use are often influenced in their choice not only by practical efficiency, but by appearance. Common experience shows that not all are influenced in the same way. Some look for artistic merit. Some are attracted by a design which is strange or bizarre. Many simply choose the article which catches their eye. Whatever the reason may be, one article with a particular design may sell better than one without it. Then it is profitable to use the design, and much thought, time, and expense may have been incurred in finding a design which will increase sales. So, okay, so that's what designs are all about, right? It's just, you know, they're applied to an article, and if it's a sexy design, then people will buy it, and that's what people want. And so I have an excellent example for that. Let's talk about kettles, okay? So kettles, all kettles have the same function. They are a receptacle with a heating element at the bottom, an on-off switch, and it heats the water in the kettle or receptacle, and then you can dispense the hot water, right? That's fine. And kettles come in many shapes and sizes. So here I have a sunbeam kettle. I don't know why it's not. There it is, the sunbeam kettle, right? Great stuff. $500 from Pick n Pay. And, you know, it's got a lid. You put the water in, stands on a base, and there's the switch, and you're good to go. This is the kettle, right? $500. Great stuff. You can make your coffee. Then we have this kettle. This is a Smeg. All right. This has a lid. All right. It's got an inside. It's got a little window where you can see how much water is in it. It's got a switch and sits on a base to heat your water, right? It's exactly the same as my Sunbeam one from Pick n Pay. The Sunbeam one costs $500. This one costs $2,800. Okay, why would you pay $2,800 for this one? Because it looks sexy, according to some people, right? Well, particularly my wife, because we have one, right? So, and I have to say, it does look cool. It's like retro, and the lettering is cool, and you get them in different colors and everything like that. So, but I mean, it's 5 times the price, man, just to make a cup of coffee. But these things fly off the shelves, okay? You cannot, you know, if you want a particular color or whatever, you're going to battle to get one. So this is a perfect example. This is very much a registered design. It's not about how it works. It's about its outward aesthetic appearance, the physical appearance of the article. This and the Sunbeam perform exactly the same function, right? Exactly the same function. But this one is 5 times the price, and people buy it because it looks sexy. And that is exactly what Lord Reed was talking about in AMP versus Utilix, whereby whatever the reason may be, one article with a particular design may sell better than one without it, and it is profitable to use the design. So this design for Smeg, this design of this kettle, is really, really worth it, because they get to charge that massive, massive premium, and people will pay it. Okay, so there we have. This is designs in a nutshell. Okay, right. That's it. If you look at the difference between designs and patents, patents protect underlying concepts, whereas registered designs protect appearance. Okay. Sometimes an article needs to have a particular appearance, but the appearance is necessitated by a function that the article is to perform. And so let's talk about, like, for example, a gear, you know, where the teeth are designed to mesh together like that. So there you've got an outward appearance, but it also means how it's designed to work. Those teeth have to have a particular shape in order to put force at a particular point at a certain degree of its rotation to turn something. So this is the realm of functional designs. That kettle just looks sexy because it's a kettle, right? But if something has to have a particular shape to work, then That's a functional design. So functional designs are kind of there for, functional designs are there to, they're kind of like petty patents, or because they cover how something works to some degree, but only in terms of its aesthetics. So they've got much lower patentability requirements. You wouldn't really be able to get a patent for it, but it's still something technical because it's got a particular shape to work. So the introduction of functional designs by the South African legislature was an attempt to cover off like the utility model petty patent, which we don't otherwise have in South Africa. And that's what functional designs are really sort of to do for. Okay, so now we understand broadly that designs cover what something looks like, either because it's aesthetic perfection or because what it looks like has got to perform a function, and you've got aesthetic and functional designs. Okay, so that's the broad division of the South African design legislation. Let's just talk about how that interacts with patents and trademarks and copyright. So I think I've spoken about patents. Patents cover how something works, designs cover how something looks. But let's talk about trademarks. A trademark, as well because you did this with Prof. Alberts last year, it's a mark used by a person in relation to goods or services for the purposes of distinguishing those goods or services from the same kind of goods or services connected in the course of trade with any other person. And as you know, that's Section 2 of the Trademarks Act, okay? A mark is defined as any sign capable of being represented graphically, including a device, a name, a signature, a word, a letter, numeral, shape, configuration, pattern, ornamentation, color, or container for goods or any combination of the aforementioned, okay? Registered designs, on the other hand, relate to designs applied to articles. I've mentioned that before, and I will mention it again. And the purpose is to protect the appearance of the article and not link the appearance of the article with the underlying goodwill associated with the supplier of the article. So let's have a look at, so it's possible because of, there's quite a degree of overlap in protection offered between trademarks and designs. Because, due to recent amendments in the Designs Act and how legislation has come on, it is possible to protect the appearance of a container by way of a trademark, right? And also new class 32 in the Designs Act, you're able to protect logos. Okay, I'll get that. We'll come to that, but that's interesting. So let's look at designs versus trademarks. Okay, so the design is either 10 or 15 years, 10 years for a functional design, 15 years for an aesthetic design. Trademark is potentially perpetual, right? There are trademarks on the register that are hundreds of years old. The scope of protection, both are limited to class, but trademarks are much more specific in the sense of what they're applied to. Time to grant, designs are very quick. They happen in less than a year, whereas trademarks take 18 months or longer. There's only formal examination of designs, but there is substantive examination of trademarks. Designs must be absolutely new. There's novelty required, but trademarks only require distinctiveness. There's no use requirement for designs, but you will know very well that there is a use requirement for trademarks. And then designs are payable, the annuities are every year, but for trademarks, maintenance fees, annuities, they're not really annuities, are they? They are only payable every 5 years as well, So, okay. So what tends to happen is, this Meg kettle, you could get a trademark for that as well, right? So what tends to happen is people file a container mark for a trademark on the kettle and a design at the same time, because you can have both can exist together. And then while everything, while the trademark acquires distinctiveness, your registered design is there protecting people for the first 10 or 15 years. Then that would fall away, it would expire. Remember, if you don't pay renewal fees, it lapses. But if you're allowed to go to term and then it finally dies after its duration, then it lapses, okay? It expires, I beg your pardon. Whereas trademarks, then you'll still have your trademark and it'll just go for as long as you want to sell it. So it's a strategy to file both designs and trademarks because there is this degree of overlap between the two. Okay, designs and copyright, because copyright is quite important as well. I mean, you think of that Smeg kettle, all the drawings and the pictures of it, etc., etc. There would be copyright protection in there, right? Okay, so one of the central tenets of copyright law is that copyright does not protect ideas, but rather the reduction of those ideas to material form. All right? We know that that's like day one, the first thing that you learn about copyright. Similarly, registered designs are not concerned with underlying concepts either, but the physical embodiment, the design as applied to an article. So there's obviously substantial overlap, right? So where does copyright begin and design protection end? Or where does copyright end and design protection begin? And okay, so we have to look at the definition of artistic work in terms of the Copyright Act. And so it says artistic work includes sculptures, works of architecture, and other works of craftsmanship. But there's a very important exclusion, which is 15.3a, which says that protection will not extend to the reproduction of a three-dimensional article, i.e. the kettle, which has been made available to the public, provided that the three-dimensional article is of utilitarian nature, i.e. it's not a work of art. So again, that's the kettle, right? And is multiplied by an industrial process. And again, they've got a production line in Italy that's pumping these things out, clearly not fast enough because of the demand. But it's not like you have an artisan making each one, right? So it is multiplied by an industrial process, i.e. not through the practice of art. So therefore, when for example, with that kettle, copyright will exist in the drawings, that the designers did, and the tolerances and the shapes and the dimensions, but it will not, copyright protection will not extend to actual three-dimensional production model, but it's in the drawings. Because the production model, it's not art and it's multiplied by an industrial process, falls within the exceptions set out in 15.3a. And so the three-dimension production model is protected by way of design, but not particularly aesthetic design, but not by copyright. So, okay, so how do you infringe copyright? So when this registered design is done, how are you protected? Well, if you take this and you reverse engineer it, so you take the dimensions and everything like that, and you make one exactly like that, you're not infringing the copyright, okay? But you would be infringing the registered design. When that registered design either lapses or expires, then you're free to make and sell these, provided you don't use the original drawings. Because when you use the original drawing, when you use the original drawings, you infringe the copyright. When you reverse engineer this one, then you would only infringe the design, because the design is concerned with the 3D appearance of it. So in the case of copyright and registered designs, they're contiguous, which means they sit next to each other, but they don't overlap. And it's important that these differences, that you understand them. All right. Okay. So the law of designs is covered by the Designs Act of 1993. There was an old one before that of 1967, which you don't have to concern yourself with at all. We've got some 1999 regulations, which are kind of important. There's a couple of, there's a Hague Agreement, which is kind of like the PCT for designs, but South Africa is not a signatory to the Hague Agreement, okay? So protection can therefore not be obtained in South Africa by filing an international application in terms of the Hague Agreement, but we can claim priority from a different Hague Agreement application. But you can't just say, I designate South Africa in terms of the Hague Agreement. That's not going to fly, okay? So that's kind of like, and then of course South Africa is a party to the Paris Convention, as well, and so we will recognize different countries' priorities. So if you filed in France or the UK or any other member of the Paris Convention, then the priority will be recognized in South Africa. I'll come back to this, but designs, very important, only have a 6-month priority, right? Patents have got 12. Designs have only got 6, so that's really important to understand. Okay, right, let's go into the nitty-gritty of designs and what they are and how you protect them, etc., etc. So that, as I said earlier, that whereas aesthetic designs find an equivalent or a corresponding mode of protection in most jurisdictions, the functional design is a unique South African creation. So what does that mean? It means that aesthetic designs have like a massive platform of case law on which they sit, because not only have the South African courts been pronouncing on aesthetic designs for years and years and years, but we also have access to a wealth of other case law in other jurisdictions, most notably the UK, which is highly persuasive. So, you know, the law on aesthetic designs is very well established, whereas the law on functional designs is much lesser. So we're a little bit at sea with functional designs. You know, we don't really know. Whereas, you know, aesthetic designs, almost every aspect of aesthetic designs has got a case discussing that aspect of it sort of out there somewhere. Okay, so an aesthetic design. It's applied to an article, okay, and has features that are appealed to and are judged solely by the eye. That's really important. Features which are judged solely by the eye. In other words, features that persuade a purchaser to select it over another article that performs the same function. And that's hence the kettles are a perfect example of that. Okay, the fact that an article performs a particular function does not mean that the design should be functional design rather than an aesthetic design. Okay, only if the article has to look a certain way in order to perform its function, i.e. a gear, will it be the subject of a functional design. Consider bottles, soft drink bottles, the Coke bottle, okay? Its function is to hold Coke and to dispense it, okay? So you can't just get an elongate body with a closed bottom and an open top and get a functional design for that, because every bottle does that, right? Many designs exist for bottles that all essentially fulfill the same function. The aim of the different designs is therefore clearly to appeal to the eye, and as such, the designs are protectable as aesthetic designs. And you think about the Coke bottle, and you know, with those ribs, and it's got a very distinctive function. I love drinking Coke out of a Coke bottle. Whenever I see Coke being sold in one of those classic Coke bottles, I always buy it, because I don't know, it's just got such a vibe associated with it. You know, I remember drinking it from those bottles when I was a kid, and I mean, I think that Coke tastes different when you drink it out of glass anyway, so as opposed to a can or a plastic bottle. And it's a real shame that so much Coke is sold in plastic bottles, but those glass ones are really the thing for me. So, you know, you can see how that design has really, you know, it places me right there, that you know, it persuades me as a purchaser to select it over other forms of packaging. So, you know, you can see just another example of how important designs are. Okay, functional designs. A functional design is the design applied to an article and which has features which are dictated by the function of the article to which the design is applied. Okay, so let's think of a metal extrusion. So, you guys are engineers, so a metal extrusion is a long, thin, shaped piece of metal, right? That just gets squeezed out of a shape thing. So the metal is molten, and then you push it and you extrude it through this thing. So it'll have like a profile shape, and it'll be long and thick. So think about a curtain rail. That's an extrusion. You think about, you know, at the bottom of your trolley door, you know, you've got that rail. That's a metal extrusion as well. It's a long, thin thing, and then if you cut it in half and look at it from the side, it'll have a profile shape, okay? So a metal extrusion may have a particular profile based on the requirement to, for example, to house a seal between, you know, the metal extrusion, if you're looking at it from the side, and a piece of glass. Such a profile would be irrelevant insofar as aesthetic considerations are concerned, because a user wouldn't even see it, right? It's just there to hold the pane of glass. You don't see it. It's not judged solely by the eye, because if you can't see it, how can you judge it by the eye? But the profile is still important because it holds the pane of glass, right? So it's how it engages the glass, and the purpose of the extruded metal rail is to hold a pane of glass in place. So That's what functional designs are designed to protect, you know, the profile shape of something like that. Because although you don't see it, so you can't judge it by the eye, its shape is important for its function. Its function is to hold a piece of glass in place, and its shape makes sure that that happens, okay? An aesthetic design registration affords the rights holder no rights in the purely functional features of an article embodying the registered design. But it is important that a functional feature of an article should also be protected, and therefore we have Part F of the register. Okay. Right, let's get into some definitions. Protectable features. So, according to the Act, okay, and this is, you know, Section 1. An aesthetic design means any design applied to any article, whether for the, and this is important, okay, whether for the pattern, the shape, the configuration, or the ornamentation thereof. Pattern, shape, configuration, or ornamentation. I'll come back to these, but they're really important. Or for any two or more of them, having features which appeal to and are judged solely by the eye, irrespective of the aesthetic quality thereof. Okay, so this is an important consideration. Nobody, no judge, no lawyer is going to say, oh, but it's a rubbish design. Nobody likes it, okay? It's like in copyright protection, you know, they don't talk about whether the work has any quality associated with it, you know, because can you imagine? You then have a judge up there saying, well, I'm not going to give any copyright to the Rolling Stones because, you know, I prefer the Beatles. I think the Rolling Stones are rubbish. I don't like their music, therefore they don't qualify for copyright protection. Nah, and you can't do that, all right? You can't introduce that subjectivity to it. And it's exactly the same in designs, right? Irrespective of the aesthetic quality thereof for an aesthetic design. You may think it's rubbish, but somebody else might really, really like it, okay? And I'm trusting that everybody here is familiar with the Beatles and the Rolling Stones, who were music groups who emerged in the 60s, right? Okay. Right. That's an aesthetic design. A functional design means, and this is again Section 1, any design applied to any article, whether for the pattern or the shape or the configuration thereof. So no ornamentation for functional designs, okay? Or for any two or more of these purposes, and by whatever means it applied, having features which are necessitated by the function which the article to which the design is applied is to perform. Okay. Then it goes on to say, integrated circuit topography, mask work, and a series of mask work. Don't worry about those, okay? Integrated circuits are electrical, electromagnetic, optical. Okay, such a small part of the law, such a tiny little part of the law that you really don't have to worry about that. So when they talk about integrated circuits, topographies, mask works, don't worry about it. We're not dealing with that, okay? That doesn't fall within the syllabus. Okay, so the fundamental difference between aesthetic and functional designs is, you know, judged solely by the eye and is necessitated by function. Those are the two, okay? But there are a couple of differences in those two definitions, which kind of unpack the difference between aesthetic and functional designs to a greater extent, okay? Before we dive into that, I just want to come back to the concept of article, which you remember I spoke about earlier. Actually, no. Let me do this. Here's a good example of the difference between an aesthetic and a functional design. Okay, don't know if you guys ever go to Woolworths, but they sell herbs. So you know, you'll get, I don't know, all different kinds of herbs. I'm not very good with that kind of thing, but you'll get them in these little boxes. Okay, and the herb is put in there, and you know, you buy it. And the whole idea behind this box, I mean, it's quite cool if you look at its shape. And so this is the subject of an aesthetic design, all right? Because it's got shape, it's got configuration, how everything works together. It's got ornamentation. It doesn't have pattern, which is a repeating design, but it does have, you know, it's got pattern, shape, and configuration. Okay, so this is an aesthetic design. Yay. Okay, easy, because it's got features judged solely by the eye. Okay, that's the box. This is what's called the blank for the box, okay? You know, this is freaking me out that it's not going into focus and stuff like that, but let me just see if I can change it. I don't know. Okay. So this is what the cardboard cutout looks like before it's folded into the box, okay? When you fold this up and move everything, then you get this, all right? This is called the blank, and this is called the assembled configuration, right? So this blank, you protect this by way of functional design because its shape and configuration dictate its function, which is how everything bends and folds together, right, to make the final box. So this you protect, that is protectable as a design, but you protect this as a functional design because it's a design applied to an article, which is a cardboard, and the pattern, the shape, or the configuration thereof, and which features are necessitated by the function which the article to which the design is applied to is to perform. Okay, so this is a functional design for the same thing as this, but when it's assembled, it's an aesthetic design, and this is a functional design for the same thing. Okay, so that's quite important. What I'm going to do is I'm going to post onto Blackboard examples of an aesthetic and a functional design of exactly what I've showed you. And then you will see how the two are put together and the differences that apply. Okay. But now, okay, so hopefully that just sort of illustrates the difference between the two. In terms of an article, it's really important that designs must be applied to an article. Okay. Therefore, a design can only be a design in the context of the article to which it is applied. And it cannot exist like as an immaterial concept, as an intangible concept. It must physically exist, applied to an article, right? Cardboard or a chair or, you know, whatever, a box, a carton. A design is something that is applied to an article. For example, ornamentation in the form of pattern of flowers, which would be a design, applied to crockery, the article, or for example, the shape of the kettle, which is applied to the kettle, right? So in terms of Section 20 of the Act, the effect of the registration of a design is to grant to the registered proprietor the right to exclude other persons from the making, importing, using, or disposing of any article to which the design is applied in a particular class, okay? So the correct interpretation of the word article is therefore important. And so you know, you've got to understand that it's you sue somebody for the kettle. You don't sue somebody for the design because the kettle has the design. The kettle is the article which has the design applied to it, right? So now we talk about logos, symbols, and the like. So we need to talk about class 32. And so I refer you to the discussion at the bottom of page 302 on Dean and Dyer. But basically, we've got a new class for the classification of designs in the Locarno classification, class 32, and it specifically extends to logos, get-up, surface ornamentation, and the like. And so we're now moving into the realm of having a slightly broader interpretation of exactly what an article is, right? So, for example, you can get designs for typefaces, for font, and you know you can get designs for logos as applied to T-shirts, footballs, shoes, caps, any other article of clothing, etc., etc. Now, our courts haven't pronounced on this, so there's only going to be certainty once our courts have had the opportunity to consider this issue in more detail. But the fact remains that, you know, people are now applying designs just to logos in terms of class 32. And yeah, so it's just something to bear in mind. Just read this. It's a little bit of a slippery eel concept. You know, what is an article? You know, in the sense of a box, an article is easy. But now when you start talking about the Woolworths logo down there at the bottom, then that becomes more difficult. Okay, because that's typically the realm of a trademark. But now we're saying You can get a design for that when you apply it to a box, etc., etc. So again, and this is why it's so useful. We can have reference to UK law about what exactly an article is. For example, an article must be portable. An article must be of substance. And photographs and cartoons are not articles, but wallpaper is. So UK law is instructive in this regard. So it's just something to bear in mind about what an article is. This is one of the sort of philosophical questions that we have to get our head around here. Okay. One thing about designs is because it's sort of got features judged solely by the eye, you can imagine that a set of articles is going to be important, and that would be a like a furniture set, one-seater, two-seater, three-seater set of sofas and chairs, a crockery set, a set of cutlery with knives and forks and spoons, etc., etc., all which have this particular design applied to them. The design applied need not be identical, but as long as variations and modifications of the design applied to the different articles are not sufficient to alter the character of the articles. So it talks about sets which might be, and examples are sets of crockery where the individual components share the same pattern or ornamentation, or a set of cutlery that all have handles that embody the new shape. Okay, so it's possible one design application, so you don't have to have a separate design application for the spoon, the fork, the knife, the serving spoon, etc., etc. One application, here's a set, thanks for playing. Okay, so the Act does make a provision for that, and there is an excellent case, Clipsal, Australia versus Trust Electrical Wholesalers, and another, and that talks about protecting a set, so you should definitely have a read of that. Okay. One interesting aspect about design law is the concept of classification, and this is really cool, and it's a big differentiator from patent law, which says you've got to classify your design in accordance with the classification provided in the regs, and so it's either going to be for cars or boxes or cutlery or whatever. And the choice of class is really important because the rights afforded by a registered design are limited to the class in which the design has been registered. So excellent example of this is a car. So I'm going to just one sec. Okay, so this is an exact representation of an Audi A4 Cabriolet, right? Okay, you can see it there. And oh, this thing is freaking me out. Yeah, there it is. Okay, so this is a toy. Okay, so it would be registered in class 21. The real car, the actual Audi A4, is a motor vehicle, and that would be registered in class 12. So when you have a design registration for the car in class 12, you can't stop somebody coming and making the exact same design, but as a toy in class 21. Okay, so it's the exact same design, it's just on a completely different scale. One's a toy, one's a car, right? So a registration for a motor vehicle in class 12 would not prevent another person from selling a toy car of the same design because the toy car falls within class 21. It's possible to file applications in more than one class, but such applications will be separate and independent and will only be enforceable in the class in which it was filed, right? So Audi, if they have any brain cells, and they do, they file the designs for their new vehicles in class 12 and class 21 to stop. And I had to buy this from Audi, and it was very expensive, much more expensive than a toy, but that's because you get your registered design from there. So, that's an example of how important classification is, and that's a fundamental difference between patents and designs, but it is a similarity between designs and trademarks. Okay, right. You'll recall earlier when we were talking about the definition that a aesthetic design is protectable by way of pattern, shape, configuration, or ornamentation, but crucially, a functional design is only shape, configuration, or pattern. Okay. So the features of a design for which protection can be claimed are those, or a combination thereof, as applied to an article. And now there's a lot of debate about what these words mean, but basically, and you could check out, Kestos Limited versus Kempat. You can check out Cal versus Canon, and they all go to town on what these mean. But basically, if we just give them their ordinary dictionary meanings, shape means the external form, contours, outline of something. Configuration means the arrangement of parts or elements in a particular form or figure. So there's a subtle difference between shape and configuration, right? Shape, external form, the contours, the outline, and configuration, the arrangement of parts, how the handle fits, the shape of the handle, pouring spout, the lid, an arrangement of parts or elements in a particular form or figure. And then, of course, pattern and ornamentation are slightly easier because pattern means repeated decorative design, whereas ornamentation just means like flowers or the logo as you apply it to it. So it's really important to understand that an aesthetic design can have one or more of these, but a functional design does not include. What does the functional design not include? It does not include. It's limited to pattern, shape, configuration. So it doesn't talk about ornamentation. Because you can see how pattern will be applicable to a functional design, because you might have a pattern of cog teeth, which is a repeated design, but ornamentation is decorative, and decorative by definition falls outside of what we're intending to do for a registered for a functional design. Okay, check out SunSmart Products, check out MCG Industries, and it gives a discussion of those. Okay. Color is quite an important aspect of registered designs, because although it's not specifically included in the protectable features of shape, configuration, pattern, and ornamentation, we do have a case in South Africa, aesthetic designs, Marley versus Piping Innovations, whereby they said that a judge remarked that he was not persuaded that a single color applied to an article seen with the article should not qualify as a design. So here they were talking about plastic pipes that were copper colored. And so the colors were dominant with a simple pattern. And so as such, that made them sort of unique and distinctive in the marketplace. So he was prepared to recognize color under certain circumstances as a design. Now, there's lots of examples where that might actually be quite relevant, and probably one of the most important ones. Yeah, Sally?
Yes, Prof. I didn't get the case law for the South African one.
Okay, it's written in Dean and Dyer on page 306, and it's Marley versus Piping Innovations.
Okay.
Sally, do you have a copy of Dean and Dyer?
Sorry for that. I'm on Dean and Dyer on, yes, the latest version. I'm on page 307 because you spoke of SunSmart Products versus Plague. And yes, the next one is.
I'm on page 306, the role of color.
Sorry, Prof.
Yep.
It's actually on page 308.
308. Okay,
Yeah.
thank you. I saw it.
308, the role of color.
Yeah.
Yeah,
Yes,
it's the
Prof.
latest edition that we have.
Oh, okay. I need to update my edition. That's interesting. Okay.
Okay, thank you. I got it.
Yeah, so the role of color. Okay, there we have it. Okay, so so we've just got that one case, Marley versus Piping Innovations, and they specifically recognize that color might work. Right, we've spoken a lot about features judged solely by the eye, and this sort of suggests that aesthetic designs are not concerned with functionality, and I think that's correct. Because if you think of the kettles, right, it's what the kettle looks like as opposed to what it does, and I think that's important. So we must understand whose eye are we looking through. So there's multiple people. There's the owner of the design, there's the manufacturer of the design, there's the consumer of the design. And I think it's really important to understand that when we say features judged solely by the eye, what we're talking about is the eye of the consumer, right? So it's not the person who makes it, it's not the person who distributes it, it's the person who makes the point of purchase decision to buy that. So a good, a design aimed at a small child, for example, will have to be assessed differently from a design intended for the adult market. So that's important to understand. It's the eye of the beholder. It is the consumer who provides the standard by which it is judged. Okay, and then the definition of a functional design includes the phrase having features which are necessitated by the function which the article to which the design is applied is to perform. This clearly indicates that a functional design must include features that are not introduced to give aesthetic appeal to an article, but rather features without which the article will not work, okay? So probably the best case we've got there is MCG versus Chestpack, which was in 2011, where it was held that if the feature of a design is not to appeal to and is not judged solely by the eye, as contemplated by the definition of an aesthetic design, and it is functional, but is not necessitated solely by the function which the article is intended to perform, it's not affected by section 1415A, which, that's the one that talks about section 14 talks about, let me get this quickly. So section 14.2 talks about the novelty criteria. And so Chestpack was talking about what was made available to the public and whether it was, and how that interrelated to function. But anyway, have a look at MCG versus Chestpack, because that's one of the few, I think, to the extent, and it only really touches on it, but talks about, the wording of the act and functionality versus aesthetics, and the importance of the word solely and how that fits in with novelty as well. So again, a little bit of a concept which I'll leave with you, but that's something you've really got to look at. And that sort of segs into the next section, which is requirements for registrability. And again, there's a distinction made between, sorry, Sally, your hand is still up? Yeah. Okay. Sorry, I just got a message quickly here that I just want to look at. Okay. Yeah, okay, we'll come back to that. I think Danae is having network problems, so I think she's signed off. Okay, so let's talk about the basic requirements for registrability, and again, as distinction is made between aesthetic and functional designs. In the case of an aesthetic design, it must be new and original, and you'll recognize the word original from copyright. And then in the case of functional design, new and not commonplace. So we really need to look at those words originality and not commonplace respectively. In terms of novelty, it's quite similar to the Patents Act in the sense that it requires absolute novelty. So it can't have been made available to the public in any way, shape or form prior to the date on which you made the application for the design. But there's an exception in design law which doesn't exist in patent law, and that is that the design law talks about something called a release date. Okay, so you can have a release date. The release date is the date on which the design was first made available to the public, whether in South Africa or elsewhere, with the consent of the proprietor or any predecessor in title. And if an applicant relies on a release date, the application for the registration of the design has to be filed within 2 years from the release date in the case of an integrated circuit topography, so don't worry about that. That 2 years is not important. It's the 6 months which applies to any other design. 6 months of the release date for any other design. So what does this mean? So like for these boxes and things like this, the manufacturer of these boxes often takes them out into the market to say, hey, what do you think about this? Do you think this will work? And only if there's market uptake do they then come to me and spend the money to have this protected by way of a registered design. So what tends to happen is a proprietor of a design releases a product to the marketplace, and then if the uptake is positive, he then has a 6-month window from the date he made the designs available to the public to make application for the registered design. And so that's a very important exception in design law, which doesn't exist in patent law. So that's yet another difference that doesn't come to pass. Is this concept of a release date. Otherwise, it's the date on which you make application for your design. It's got to be completely novel. It can't have been made available to the public, but for this release date concept. Okay, it's got a few more other exclusions, most notably Section 17, which provides that the registration of a design shall not be invalid by reason only of the fact that the design was disclosed, used, or known prior to the release if the proprietor prove that such knowledge was acquired without his knowledge or consent, and that once he learned of this being made available to the public, he immediately applied for his design. So there's 2 criteria. The design must have been largely sort of unlawfully acquired and released unlawfully, and as soon as the proprietor heard of it, he's got to get in there and make application for it. Okay. There's another one which is quite interesting, which is about the cars that we were talking about earlier. A further exclusion to absolute novelty arises where the proprietor of an existing design is exercising the design only in the class in which the design has been filed, but he subsequently decides to extend the design to articles falling in a different class. And for example, if the manufacturer of a motor vehicle has previously filed a design in class 12 to protect the appearance of the actual motor vehicle, and he's only been selling motor vehicles, it would still be possible for him to file a further design in class 21 for toys if the intention was to start selling toy replicas of the motor vehicle. Such a design can, in fact, then only be filed by the proprietor of the first design. So that's another important sort of exemption to or exclusion from the novelty provisions. Another point of distinction, it's important to note that the Act does not include any provision in terms of which a disclosure as part of a reasonable technical trial will not be regarded as novelty destroying. So disclosures at trade shows, etc., destroy the novelty of the design. So that's important, unless of course you choose to go the release date option. That's important. Okay, the test for novelty we're not really going to go into. It's just a question of determining the scope of protection of the registered design, determining the importance of the relevant prior art, and comparing the two. So that's not really too much. What I do want to talk about now is the difference between originality, which is required for aesthetic designs, and not commonplace, which is required for functional designs. So the big case for originality is Clipsal versus Trust Electrical Wholesalers. And it was held that the meaning of the original is the same or akin to the meaning in the copyright law. And so they quote Farmer's Bill there. So it talks about the design for which protection is claimed has not simply been copied from the design of an earlier article. It must be original and independent shape, configuration. If the court is satisfied that it is simply a slavish copy, then it is not original in the copyright sense. So in summary, originality means that the designer or author must have expended some skill or labor in the creation of the work. Originality does not mean that the work must be novel or unique. So originality is distinct from novelty, which is, we use patent law as our stepping off point, being aware of the differences there. This one it can't be a slavish copy. Not commonplace, as it is applied to functional designs, is a lot more tricky because it hasn't received any attention in our courts. The dictionary definition of commonplace yields not usual, or sort of commonplace means not unusual or ordinary. And the closest we've got is Ocular Sciences, which indicates that any design which is trite, trivial, common, or garden, hackneyed, or of the type which would excite no particular attention to those in the relevant art is likely to be commonplace or considered commonplace. So again, if your design is not trite, if it's not trivial, then you've probably hitting the not commonplace requirement. Right, let's talk about additional requirements. Unity of a design, I'm not really going to talk about that because that kind of figures into the set. Generally, you're not allowed to cover multiple designs in a single application. But in practice, particularly because the registrar does not review designs, a design application including more than one embodiment will in all likelihood proceed to grant. And that's quite common practice in how things are done, because designs can be linked, and so you can kind of argue that they're a set or that they're different embodiments of the same design. So it is possible to kind of get those through. If push comes to shove on something like that, the only really way to get around that would be to take the decision of the registrar on review, and I think that might be quite tricky to do, and it's certainly never been tested in our courts, so we'd have to have a look at that. Okay, we spoke about it earlier, multiplied by an industrial process. Okay, so a further requirement for registrability is that the article to which the design is applied must be intended to be multiplied by an industrial process. And you can see how this is coming back to section 15 and, you know, where copyright intersects with the Designs Act. So this excludes once-off works of art protected by copyright, and it excludes sort of artisans making baskets and things like that because they're all handmade. Okay. Breast designs, the court had to consider the meaning of the same wording used in the Copyright Act, and they were prepared to push that bounds a little bit. So they accepted that the concept of an industrial process doesn't have to be limited to the manufacture by a mechanized process. But an industrial process sort of suggests that there's a line or some kind of efficiency, and the intention is to mass produce. That would be the sort of concept behind it. So the only requirement is for the protected features to be consistently applied to each article as it's manufactured, and for such features to remain substantially similar in appearance, even if they're not exact copies. But so a single artisan making a basket, you know, making a couple of baskets, they're probably not an industrial process, but a number of people all making them the same, that can be considered an industrialized process. Again, not black and white, an area of gray, but breast designs is definitely the right sort of what you should be looking at in terms of an interpretation of that requirement of registrability. Okay. Spare parts. Oof, it's tricky. In terms of section 14.6, in the case of an article which is in the nature of a spare part for a machine or a vehicle or other equipment, no feature of pattern, shape, configuration of such article shall afford the registered proprietor of functional design apply to any one of the articles in question any rights in terms of the Act in respect of such features. So this hasn't really been considered by the courts, but in the nature of implies a broad interpretation of exactly what is a spare part. So the term spare part should be given a broad interpretation and should include both parts that are designed to wear out and be replaced, for example, brake pads, and parts that are replaceable, even though the intention of the designer was not for the part to have a limited lifetime, for example, bumpers or things like that as parts of the car. So this exclusion in terms of 14.6 only relates to functional designs, and it's therefore arguable that it would be possible to obtain protection for some articles that are in the nature of spare parts, which have features that appeal to the eye and which are judged solely by the eye. In these rare circumstances, it may be possible to protect the non-functional aspects of a spare part as an aesthetic design. So this is the difference between aesthetic and functional designs, and it's another example of why aesthetic designs are more preferable to functional designs. And this is a question that I really want you guys to be thinking about, right? Is, you know, if you could have both, or you could only have one, which one would you rather have, a functional design or an aesthetic design? And, you know, I think aesthetic designs are just generally more preferable for a number of reasons. And, you know, I wouldn't be surprised if you got an exam question saying, why would you prefer an aesthetic design? And this is one of the things where you would be getting marks for, is to say, wow, you know, section 14.6 only applies to functional designs. But, you know, if you have an aesthetic design for a spare part, that's what I'd be looking to license. And there's other things, you know, aesthetic design is 15 years. A functional design is 10 years. You know, an aesthetic design rests on a whole platform of case law, both South African and international. Functional design, it's in the wilderness. We've got very little, if any, case law on it. It's uniquely South African. So its interpretation is a lot more up in the air, whereas there's a lot more judicial certainty around aesthetic designs. So this goes to an analysis of the two and why an aesthetic design is probably preferable to a functional design. So yeah, that's something that I would definitely recommend you focus on in reviewing in studying designs. Okay, so yeah, we're now going to skip ahead to the procedure for obtaining a registered design, and there's a couple of differences here as well. Who can apply for a registered design? And the answer is the proprietor of a design may apply for the registration thereof. So who's the proprietor? That can be either the author, the creator of the design, a person for whom the author has executed the design. So what does that mean? You've paid somebody to create a design for you. You are the person for whom the author, the creator, has executed the design, so you own it. An employer, so the guys who work at this cardboard manufacturer, you know, in terms of their employment, they're designed to design boxes. This is it automatically belongs to the employer, okay? And then the person to whom the ownership of the design has passed, for example, by way of an assignment. And so it's similar to patent law because you've got the inventor and here you've got the author, but there are differences. And just like inventor is not defined in the Patents Act, author is not defined in the Designs Act or the Copyright Act, but it's been considered by the courts, you know, Pan-African Engineers, Nottage and another. And so that's the important distinction to have it. You don't need a deed of assignment. You don't need to prove right that you've got the rights from the author. It just comes into being, and you don't have to list the author like you have to list the inventor for a patent application. You don't have to list an author for a design application. Okay, so there's quite a lot of paperwork which surrounds a design, and it's just important to understand that where designs come from publicly funded research, those dreadful provisions of the Intellectual Property Rights from Publicly Financed Research and Development Act, the IPR Act, they apply. So copyright might fall outside of the realm of the IPR Act, but designs do not. They fall within the IPR Act. So that's important to understand. Okay, let's just get back to the paperwork for a design application. It's a bit of a nightmare. The first thing you have to do is you have to say which register it goes on, A or F. So you've got to say what type of design that is. You've got to have proper representations of the design. Now, like I said, I'm going to upload both an aesthetic and a functional design to Blackboard, and I want you to look and see the differences there. So, you know, you've got to look and like, I mean, there'll be multiple representations of this, you know, front, underneath, plan, side, other side, etc., etc. Whereas, you know, for this one, what are you going to do? That's it. That's the design. So you don't have to have multiple representations for a functional design. Or sometimes you do, depends on what it is. Obviously, you need a title. This will be a box or a carton, and this will be a blank for a box or a carton. Okay, that's the title. What class is it in? Those are in class 9, but class is very important from an infringement point of view, etc., as we mentioned earlier. You've got to say if there was a release date or not. You've got to say if it claims priority or not. Remember, priority is 6 months as opposed to 12. You've got to have a definitive statement. I'll give you an example of definitive statements later. If you like, you can have an explanatory statement, which is to say, you know, an explanatory statement just kind of gives sort of some context to it, and then you've got to have a declaration from the applicant to say that she's the proprietor and a power of attorney, so that we, Spur and Fisher, or whoever can act for you. So, you know, there's quite a few hoops to jump through. So let's just spend some time talking about the definitive statement because it's of particular importance. And Clipsal is the case. Clipsal is a really important case when it comes to design. So, you know, you really need to, you know, there's a couple of cases that you need to have read, but Clipsal is one of them, trust me. So the definitive statement, it's kind of like the claims with a patent application. It defines the scope of the claim protection. That's the bottom line, right? So the purpose of the definitive statement is to set out the features of the design for which protection is claimed, and the definitive statement is used to interpret the scope of protection afforded by the design registration. The definitive statement sets out which of, you know, of shape, configuration, pattern, or ornament, or any combination protection is claimed for. So it'll say which of those, whether the design is applied to a whole article or only part of the article, and whether any features that are shown in the representation should be disregarded. So, you know, when you look at those design applications, you'll see sometimes parts of it are shown in dotted line, and it'll say any shape which is shown in dotted line is excluded from the ambit of protection of this design. So the definitive statement is really important. So if you turn over, you can see some examples of definitive statement. And, you know, the first one is for football. The features for which protection are claimed reside in the pattern, animal, ornamentation as applied to a soccer ball, substantially as shown as the accompanying representation. You can see the shape and configuration for a soccer ball is not relevant. All soccer balls are round, or should hopefully be. But what you really want, because of this one, you've got pattern, you've got those repeating little triangle things, and then you've got ornamentation, which is, you know, like the little Adidas logo, the FIFA logo, the signatures, etc., etc. And so it goes down, aesthetic, aesthetic, aesthetic. And then when you look at functional design down at the bottom, you can see that there's no ornamentation there. So it says the features for which protection is claimed reside in the shape and a configuration of a vacuum tube, substantially shown in the accompanying representation, irrespective of the length of the tube. And that is, of course, the cross section through the tube, so you can see the shape of the gaps in the tube, and they obviously have some function designed there. So that's the difference between the definitive statements in between aesthetic and functional designs. Okay. Right, let's talk about section 15 or section 20, and which is the equivalent to section 45 in the Patents Act. So, you know, I'm always banging on about section 45 and how important it is, because it says, you know, you have the right to exclude others from making, using, exercising, disposing of, offering to dispose of, or importing the invention in South Africa. And there's a slightly different ambit provided in terms of the Designs Act, because once the design application has proceeded to registration in South Africa, the proprietor of the design is granted for the duration of the registration the right in South Africa to exclude others from making, importing, using, or disposing of any article included in the class to which the design is registered. Okay, so two important things. The right is limited to articles included in the class to which the design is registered. And the other very important aspect are the acts of offering to dispose and exercising are excluded from the infringing acts, okay? So they're exclusive to the Patents Act. They don't appear in the Designs Act. Accordingly, advertising the future sale of an article embodying a registered design is allowable, provided it is not done in conjunction with the manufacture, importation, use, or disposal of that article. Now that's a curious distinction between the two acts. That's a curious difference. And I got to be honest, I don't really fully understand why, but it's interesting that you can advertise that. You can advertise a design or an article to which a design is applied for sale, but you can't then go and sell it, and you can't use it or import it. Weird, huh? Anyway, just how it works, okay? Another kind of like interesting difference between patents and designs is revocation, right? So, you know, one always wonders about these things, about was it intentional that they left out a word or they left out these acts? What did they mean by that? You know, what was the intention of the legislature? And you know, when you leave out two acts, you kind of got to gravitate to think, okay, maybe that wasn't intentional. There's a reason for that. But when it comes to revocation, they only left out one word, but the difference is quite profound, right? So you will recall that the grounds for revocation in terms of the Patent Act are exhaustive. They list those grounds. Oh, sorry, Tabiso, you've had your hand up, yeah.
My apologies, Prof. Looking at aesthetic and functional designs, on that examples we've been discussing, I can see they can get a bit complex. So I'm wondering who actually handles applications pertaining to designs. Is it the trademark attorney or the patent law attorney?
Patent attorneys.
Okay, thanks.
Because you know you can have this functionality in there, which is quite important, and there's a lot more, the way they're revoked, the priority, the excluded acts, etc., etc. Designs are much closer to patents, although there's commonality between trademarks and patents. Designs are much closer to patents, so they are almost exclusively left to patent attorneys, particularly because of this functional design and the role of functionality in it.
Okay, thanks, Prof.
Okay, the nature of the grounds for revocation. Yeah, so you remember in the Patents Act, the grounds are exhaustive, which is to say they list the grounds and no more are allowable. And that's because it specifically states in section 61 of the Patents Act that a revocation application can be made on any one of the following grounds only, namely, and then it goes on to say that. But the equivalent wording in the Designs Act says that the corresponding wording is on the following grounds, namely, with the notable exclusion of the word only, okay? So it's arguable that the list of grounds for revocation in terms of the Designs Act is not exhaustive. But then Ludi goes on to talk about expressio unius est exclusio ulterius. I don't know what that is, but he uses it to argue that it's more likely that the list is exclusive. But it really, I'm not sure if anything turns on this, but I think there's definitely an argument to say that a big difference is that it's clear. In the Patents Act, they're exhaustive. In the Designs Act, the list of reasons for revocation are not necessarily exhaustive. And you might be able to leave it in another one. You can certainly have a go, that's for sure. So in terms of section 31 of the Designs Act, the grounds for revocation are as follows. The application for the registration of the design was not made by a person entitled to. Okay, that's easy. The registration of the design is in fraud of rights of the applicant or any person under or through whom he claims. Again, very similar to the Patents Act. The design is not registrable under Section 14. The application for the registration of the design contains a false statement or representation, which is material and which the registered proprietor knew was false at the time when the statement or registration was made, okay? And that the application for registration of the design should have been refused in terms of Section 16. Okay, so the two that I'm just going to focus on there are 3, 4, and 5, or the three that I'm going to focus on there are 3, 4, and 5. Design not registrable under Section 14, okay? So that it's not a design as defined, so it's not as applied to an article, it's not aesthetic, it's not functional. It's not new, it's not original, it's not commonplace. It's not intended to be multiplied by industrial process. It's an aesthetic design and the features are detected solely by function, or it's a functional design relates to an article in the nature of a spare part. So remember, aesthetic designs don't do that. And you could also argue maybe that it's a functional design, but the features are judged solely by the eye. Okay. So Section 14 just is like the same Section 25 in the Patents Act. It's not new, it's not novel, it's not inventive, etc., etc. It's the equivalent there. And then Section 16 is, I'll come back to the false statement. Section 16, if the application was not made in the prescribed manner, so for example, if there's not a power of attorney, if there's not the declaration on Form D3, etc., etc., and so the registrar will refuse it on that basis. Okay, a false statement. You remember me banging on about this in patent law, and that's the two forms that need to accompany a patent application, which have got declarations on them. And if you make a mistake on that declaration, it's really serious. And that is the Form P3, which says that you've got the rights, and it's not the first application filed, or it claims priority from the first application filed. And then the Form P26, which talks about the Biodiversity Act, and that does it relate to an indigenous resource, and if it does, that you've got all the benefit sharing agreements in place, and you've got all the permits, etc., etc. If you make any misstatements on those, you are in for the high jump. So a design will be open to revocation if the application for the registration of the design contains a false statement which is material and which the registered proprietor knew was false at the time when the statement or the representation was made. It is important to note that the false statements must be material and that it requires knowledge on the part of the applicant. So this is another difference between patents and designs, because you will recall that when we spoke about this in terms of patents, there was a recent amendment to the Patents Act that said that the proprietor knew was false at the time when the statement, the representation was made, or ought reasonably to have known. That broadens the liability there quite significantly. That broadening is not incorporated into the Designs Act, okay? So it's just he knew. He either knew or he didn't know. Whether he ought to have known is not a consideration in terms of the Designs Act. And I think that's quite an important factor as well. And then it talks about, the examples of false statements. And so there we go. So those are, how you're going to revoke a design. There's no opposition for designs. There's no third-party observations for designs. It's just the design is granted, and if you don't like it as a third party, you got to get up and have a go against it. There's no specialized court like there is for patents. Patents have got the Court of the Commissioner of Patents. For designs, an application for revocation takes the form of an application to the High Court. And so both the proprietor and the registrar are cited and respondents. There's no dedicated court having jurisdiction, and the normal rules of High Court procedure apply, okay? And then we go on about Form D14. We don't have to worry about that to any extent, okay? Let's put the boot on the other foot. Revocation is when a third party comes and tries to have a go at you because your design doesn't comply with the requirements of the Act. Infringement, it deals with where the proprietor is of the view that somebody is infringing the design in the sense that he's making, using, disposing of, importing or keeping, no, importing or I can't remember. You know those 4 acts. Okay, who can introduce locus? Who's got locus standi? The proprietor, but he has to give notice to every licensee who's recorded as such on the register, and the licensees can then come in as co-plaintiff. And the only exception to this rule, which is the same in patents, is that if a licensee has been granted an exclusive compulsory license, then he is able to institute infringement proceedings. Again, you've got this construction, determination of infringement, and you go through those 4 steps. Is the act of such a nature that it could constitute an infringement? Is the article included in the class? Class is an important point. Class in patents is not relevant. Class in designs is absolutely essential. The alleged infringement falls within the scope of the registration, and the defendant or respondent, is there a defense? Is the design valid? Does he have a license? Is the exhaustion of rights, etc., etc. So, as above, as discussed in paragraph 7.4.3 above, the proprietor of a design is granted the right in South Africa to exclude others from, and these are the 4 acts: making, using, disposing of. So what is it? It's making, importing, using, or disposing of. Offering to dispose of and exercising are not included. Okay, so again, the acts of infringement are they're not defined by the act, but the acts of infringement include making, forming something together by putting together the parts, importing, making goods abroad and subsequently importing them into South Africa, but that doesn't extend to goods in transit through South Africa. Using means taking, holding, deploying as a means of accomplishing or achieving something, and disposing of, getting rid of, dealing out, or distributing, including selling, letting, and donating. And so that, again, that would be very, very similar to the sort of Patents Act. Again, I really can't emphasize this enough. Because of the class-specific nature of South African registered designs, the next step is to ensure that the act of infringement is committed in the class to which the design has been registered. If a design is for a new shoe design, but a third party is selling key holders in the form of the shoe, the design will not be enforceable against the third party, even if it's identical. The design may therefore lawfully be applied to articles which do not fall within the registered class. Okay, then the assessment of infringement, I'm not really going to go through that. I think you can kind of see it in terms of it's very similar to patent law. The defenses, again, also very similar to patent law: non-infringement of the design, invalidity of the design, exhaustion of rights. Then they talk about use of an integrated circuit, which you don't have to worry about. Performing the infringing acts prior to the registration of the design. So that would kind of be the Gillette defense, because if it anticipates, then the difference between anticipation and infringement. Leave and license and acquiescence, election, waiver, and estoppel. And so, again, very similar to patent law. So to the extent you've studied those in patent law, that is directly attributable to design law. Okay, the remedies are identical. So you have an interdict, you have a delivery up or surrender of any infringing product. You have damages, which will be by way of lost profits or more likely a reasonable royalty, and then costs. So again, very, very, very similar, and 7.64 in Dean and Dyer really sets that out nicely. And again, just like revocation, the regulations do not provide a specific process to be followed. In the case of design infringement proceedings, then the patentee can therefore make an application to the High Court in accordance with the Uniform Rules of Court. Correction and amendment, again, not so important, but it's going to be the same as patent law, and so you can look at McCauley Corporation versus Brickell, where he talks about the difference between a correction and an amendment, and a clerical error for correction is an unintentional careless error, but there's a little bit of in Hokuriku Pharmaceutical versus Cipla, there's a different test closer to the UK law that a clerical error must be made in a mechanical process such as writing or copying. And so, again, I don't think anything really turns on this. We've kind of beaten this to death in patent law, and they're directly applicable, across into design law. An application to amend a registered design is open to opposition by a third party, which is not the case with an application to amend a design application. So again, it's pre and post grant. You've got to understand that distinction. Just like in patents, it's really important. A P12, there's a pre-grant amendment. There's a lot more you can do to a patent in pre-grant than post-grant. So you've got to bear that in mind. Okay. Quickly, let's just talk about restoration. In order for a registered design to remain in force, annual renew fees payable from the end of the third year. Again, very similar to patent law. If a renewal fee is not paid, the design will lapse, okay, as opposed to expire when it goes to term. 6-month grace period for late payment of the renewal fee is available upon application to the registrar and subject to the payment of an additional fee. And Section 23 provides that where the registration of a design has lapsed owing to non-payment of a renewal fee within the prescribed period, the registered proprietor may only apply to the registrar for the registration of such registration. And you've got to satisfy 2 criteria, exactly the same with patents, that the failure to pay was unintentional and that there's no undue delay. That's the wording that we use, undue delay, between the time when the proprietor became aware of the fact that the design had lapsed and the time when the application for restoration was made. Okay. And then there's recourse for third parties who had begun to exploit the design during the period between lapsing of the design and its restoration. So again, it's very similar to patents. Assignment and licensing are dealt with, that we spoke about. I think I've still got to send you the checklist of questions for designs. So let me make a note of that, because I always seem to forget that. Okay. Right. And that's it. We don't talk about traditional designs because they're divided into indigenous designs and derivative indigenous designs. The concept of traditional designs was introduced by the Intellectual Property Laws Amendment Act, but that hasn't been promulgated yet. So although these traditional designs are waiting in the wings, this is not something that it's not law yet. So as such, it falls outside this syllabus. And so you should know that traditional designs, you can read it for interest, but they don't exist per se, although the sort of framework is there, but it hasn't been promulgated yet. So I think that brings us to the end of the syllabus. I have flown through designs, but I have, if you look at this lecture, everything you need for the exam is in this lecture, all right? So to the extent that I haven't covered something, or I've been a little bit, I've flown over something, you can accord it less importance. But there are clues in this lecture as to what you need to focus on for the exam. So what I'm going to send to you is a couple of designs so that you can see, and I've also got another presentation from the South African Institute, which I think is important because it just kind of goes through what I've said, but in a different way. And it's always a good idea to have 2 different perspectives on the same subject matter, right? So have a look at this. Have a look at this presentation, and then have a look at Dean and Di, and have a look at my lecture, and then you can see how it all focuses on this main concept. So there'll be 20 or 25 mark question in the exam on design. So it's a bit, it's only one lecture of 7, but it is quite an important part, and a large part of it. Designs is pretty simple, but we need to focus on the difference between patents and the designs, and we need particularly to focus on the difference between aesthetic and functional designs. And if you get those concepts, then you're good for the exam. So I think that's it for today. I'm going to obviously upload this lecture. I'm going to upload the documents onto Blackboard. Got any questions, just reach out to me. talk amongst yourselves as to when you want the revision lecture. The revision lecture will go back over the syllabus, touch on the important points, talk about the exam, the structure of the exam, the duration of the exam, give you some exam tips and tricks. And yeah, and I think that's it. So unless there are any questions today, I think we're probably good. So yeah, what was this, 1 hour and 3/4? That's not too bad. Any questions before I sign off? Okay, good stuff. All right, thanks guys. I look forward to hearing from you about when you want your revision lecture, and then we'll take it from there and watch Blackboard for the uploads. They'll come through this weekend. All right, thanks guys, and see you soon. Cheers.
Thank you. Bye.
Thanks Sally. Thanks Thabisa. Bye now.